Right, good afternoon, everybody, and welcome to 39 Essex Chambers webinar on cross-border personal injury claims, recent developments. My name is Bernard Doherty. I'm a member of Chambers at 39 Essex and a practitioner in personal injury law, but with a particular subspeciality in cross-border cases, and I'm the lead author of the book Accidents Abroad, which is published by Sweden Maxwell and in its second edition, if any of you don't have a copy. And with me this afternoon is...
Good afternoon, everyone. My name's Vaughan Jacob. Like Bernard, I'm a barrister at 39 Essex Chambers, specialising in personal injury law with a keen interest in cross-border cases and also those cases which involve an element of fraud.
Now, just before we start with the substantive talk, I want to say a couple of things. Firstly, that the civil liability group within 39 Essex, along with the other groups, but the civil liability group being the group to which Vaughan and I belong, has been active during lockdown and quasi-lockdown and tier 1, 2 and 3, and has produced a number of webinars which are available on our website. So do have a look if you haven't seen those. Also has a continuing regular program, so look out for updates. This will be recorded and it will be sent to you afterwards, and you will probably be familiar with this, but there is the ability, there's a Q&A button, which I think most of you will find towards the bottom of your screen if you hover the mouse over it, and you can submit questions which we will see and we will try to answer. Apologies if we don't get round to all the questions, but we will try to. And in answering those questions, we will not identify the person who's asked it, which is not us being rude, but because this is being recorded, Mr. GDPR says that we shouldn't identify people by name. So that's the preliminaries. Let's get down with the main business of the afternoon. So here it is, cross-border personal injury claims. What are we going to talk about this afternoon? Well, it would probably be surprising and maybe even disappointing to you if we didn't touch upon the first topic, namely Brexit. Professor Briggs, one of the leading English modern academics on conflict of laws, wrote a book on the European revolution in conflict of laws, describing how over the last decades the common law has been very largely superseded in conflict of laws by a body of European law. Well, we are about to have a very abrupt counter-revolution from 11 p.m. on the 31st of this month. One might ordinarily expect that in those circumstances we would have great clarity about the regime which is going to supersede the European regimes. And it would be an exaggeration to say that we have no clarity at all. Some things are reasonably clear. There are, however, still large areas of uncertainty. We can't tell you with any certainty what is going to happen, but we can, we hope, be helpful in exploring the uncertainties and exploring the possible avenues for future conflict of laws rules in our area. So we're going to deal with that first, and that will take probably half the period of the webinar. And then we are going to look fairly briskly at a number of decisions, I think all from 2020, which bear upon our area, being cross-border personal injury work. And we will take those at a bit of a trot, but you will have the slides and they will give you the references and the details, and they'll be available for you to consider at more leisure. So, without further ado, I'm going to hand over to Vaughan, who's going to deal with the applicable law, the choice of law aspect of the Brexit side, and he's then going to hand back to me to deal with the jurisdiction aspect of the Brexit. Vaughan.
Thanks very much, Bernard, for that introduction. If we just move to the next slide, please. We're going to talk about the transition period and the position that we're in now in respect of choice of law, and when that transition period ends at 11 o'clock on the 31st of December. We can see the dates on the slide. Although Britain formally withdrew from the EU on the 31st of January 2020, we've been saved great difficulty by the withdrawal agreement. And this was put into place a transition period during which most EU law continued to apply to the UK as if it remained a member state. And that included continuing reference to case law of the European Court of Justice. So in short, from a legal perspective in this area of law, since 31st of December 2020, things have thankfully remained largely the same. The purpose of the transition period was, of course, to give some breathing space to the UK and the EU to put into place agreements post-transition, which would clarify how issues such as jurisdiction and enforcement would be treated in a post-Brexit world. Unfortunately, as I'm sure you're all aware, the deadline is fast approaching and it expires at 11 p.m. on the 31st of December. So we're going to look at three important issues in any cross-border personal injury case and how they might be affected post-expiry of the transition period. Let's say, for the sake of example, you live in England, but you decide to take a trip to Spain, lockdown permitting, of course, and you're injured whilst you're there. You're going to worry, if you decide to bring a claim, about the following. Firstly, which law will apply? Will it be English law or Spanish law? Secondly, which court will hear the claim? Will the English court have jurisdiction or the Spanish court? And thirdly, will a judgment be enforceable in other EU states if obtained in England or in Spain? So moving to the first of those issues and the possible conflict of laws. Whose law would prevail in our scenario? Although you live in England, you're injured in Spain. The choice of law in the past and currently is governed by two regulations, Rome 1 and Rome 2. Rome 1 applies to contractual obligations and to contracts entered into on or after the 17th of December 2009. It has direct effect throughout the EU, except for Denmark, which opted out. The current rules for determining choice of law in relation to non-contractual tortious obligations are contained in the Rome 2 regulation, and that's the regulation which we're going to look at in detail today, because that will apply in the personal injury context to road traffic accidents abroad, accidents in swimming pools, and other such accidents. Now, at present, thanks to the withdrawal agreement, both Rome 1 and Rome 2 apply on a reciprocal basis in both the UK and the EU with respect to any contract concluded and any talks committed prior to the end of the transition period. And we can thank Article 66 of the withdrawal agreement for that. So, although Britain left the EU some time ago now formally, the withdrawal agreement has proved to be a useful stopgap. What's going to happen on the 1st of January 2021? Well, the good news is there's no real change. The conflict of laws issue is much easier to resolve than the jurisdiction issue, which Bernard's going to talk about in due course. Immediately upon the conclusion of the transition period at 11 p.m. on the 31st of December, the rules of both Rome 1 and Rome 2 will be incorporated into UK domestic law. And the piece of legislation giving effect to that is the EU Exit Regulations 2019. You'll note the date. The regulations were originally intended to come into force on exit day in the event of a hard Brexit, but they're now intended to come into force at the end of the transition period instead. The position could still change if before 31st of December, Parliament enters into a new agreement between itself and the EU, which would render Rome 1 and Rome 2 obsolete. But there's no sign of that happening at the moment. So for the time being, Rome 1 and Rome 2 will continue to have direct effect in the EU, and it will continue to be enforced in the UK as part of UK legislation. It is possible for things to change in the future. There's the possibility, now that Rome 1 and Rome 2 have been converted into UK law, that it will be amended by UK legislation. And it's possible over time that the approach of the UK courts to interpreting Rome 2 will diverge from the courts in EU member states. And that's because after the 31st, we're no longer bound by decisions of the ECJ. We can have regard to them under Section 6 of the Withdrawal Act, but the Court of Appeal, the Supreme Court, aren't bound by the highest European court. So it may be in the future that we have a UK version of Rome 1, which has been interpreted differently, and an EU version of Rome 1 or Rome 2. Any amendments the UK makes to Rome 2 won't affect the EU Rome 2, and similarly, the UK won't be required to mirror any amendments the EU makes to its own Rome 2. So there's the potential, at least, for legislative divergence. Another interesting issue arises in respect of interpretation. Recital 7 of Rome 2 indicates that it should be interpreted with reference to the Brussels 1 recast regulation, which deals with enforcement and jurisdiction. Now, the Brussels 1 regime, which Bernard will talk to you about, will no longer bite. So in the future, the UK Rome 2 won't have to be construed with reference to the Brussels 1 recast legislation. However, that's searching into a crystal ball at the moment. Those changes, if they do emerge, are not likely to emerge for many years because it will take that long for the UK to reinterpret Rome 1. In the near future, in January 2021, we're dealing with Rome 2 as it currently is, and I'm just briefly going to run through the main general provisions in Rome 2 that you'll encounter in cross-border claims. So the most important general rule is found in Article 4, which is on the slide in front of you. Rome 2 concerns events giving rise to damage where the events occurred on or after 11th of January 2009. The general rule is that the law applicable to tortious claims is the law of the country in which the damage occurs or is likely to occur, and that's the lex loci damni. Now you'll see in the slide, the occurrence of damage is given primacy, and it's distinguished from events giving rise to damage or from indirect consequences of that damage. What does that mean in practice? Well, if we consider briefly a fatal accident claim, the deceased may have died in a road traffic accident abroad, but the indirect consequences of that accident on his family, who are based back home, it may be appropriate to consider a different legal regime in looking at quantification of such a claim. And that was the scenario in the case of Lazar and Alliance. Mr. Lazar resided in Romania. His daughter sadly died as a result of a road traffic accident in Italy. Mr. Lazar sued the Italian insurance company, the defendant, Alliance Italia. His claim for losses arising out of his daughter's death was found by the European Parliament to be ricochet damage, i.e., it was indirect loss occurring to someone other than the person who had suffered the tort, i.e., the daughter. So the ratio of that case, and the ratio with most personal injury cases you'll deal with a cross-border element, is that the damage occurs where the accident leading to personal injury or death occurs, not where the dependents or family members suffer their losses. There are some exceptions to the general rule. The first of which is that if we could just jump one, thank you, Bernard. The first of which is in relation to a habitual residence. So the general rule won't be applied where both the claimant and defendant have their habitual residence in the same country. That's been interpreted in a family law case, LC Children case in the Supreme Court, as a question of fact. So the court will look at whether the residence of a particular person in a particular place acquired the necessary degree of stability. In LC, Lady Hale and Lord Wilson held that a child's own wishes, intentions, or decisions about what should happen in the future shouldn't be taken into account for the purposes of defining a habitual residence. That reasoning was applied in a personal injury context and a cross-border PI case in Winrow and Hemphill. And very briefly, the claimant in that case was a UK national who was injured in a road traffic accident in Germany. He was a rear seat passenger in a car driven by the first defendant. The car collided head-on with the first defendant's vehicle, and the first defendant admitted the accident was her fault. The claimant had moved to Germany with her husband after he'd been posted there by the British Army, and they'd been living there for over 8 years at the time of the accident. They had a close connection to Germany. They lived on a British Army base, 3 children attended an army-run school, and the claimant was in fact employed at that school. But she said she always intended to move back to England sometime in 2012, which was about 3 years after the accident. The first defendant in the case was also a UK national whose husband was also employed by the British Army, and she'd lived in Germany for nearly 18 months at the time of the accident. The second defendant was a company registered in England, and it was the first defendant's motor insurer. After the accident, the claimant returned to England and brought proceedings against the first and second defendant. And the question for the court was, did English or German law apply? Although the country in which the accident occurred was Germany for the purposes of Article 4.1, the claimant argued her habitual residence was in England, where she now lived. Now, Mrs. Justice Slade found it was irrelevant that the insurer was a UK insurer. And as for the habitual residence of the claimant, she'd been resident in Germany for a long period. She was employed there, her children were schooled there, and there was no evidence that she lived in England at the time of the accident. And for the purposes of that claim, consistent with LC, her intention to return one day to England was irrelevant. So Article 4.2 was decided against her, and it was held that she was habitually resident in Germany. Another exception that you may encounter in practice is under Article 4.3, whether there's a close connection or whether the tort is manifestly more closely connected with another country. If it is, in that scenario, that country's law will apply. If we consider Article 4.3 in the context of the case we've just been discussing in Winrow, the claimant also argued that 4.3 would apply if she wasn't habitually resident in England. The circumstances surely suggested that the claim was manifestly more connected with England. But again, Mrs. Justice Slade found against the claimant. The judge found the standard to trigger the close connection test was very high. In fact, under Recital 18 of Rome 2, it was deemed an escape clause, and that was for good reason. The judge found it had to consider all the circumstances and a balancing exercise. But even though the claimant lived in England at the time that the claim was instituted, that she continued to suffer pain and require medical treatment in England, and that the courts of England initially had been seized because proceedings were issued there. On the other hand, the accident had happened in Germany, the claimant's injury was sustained in Germany, and both the claimant and first defendant had been habitually resident in Germany at the time of the accident. In that balancing exercise, Article 4.3 was held not to be made out. Article 4.1 wasn't displaced, and the applicable law was German law. So it seems that as long as there's real arguments supporting a closer connection between the tort and the country in which it occurred, Article 4.3 is a difficult argument to mount. But the other case, which is listed on the slide, Marshall and MIB, is a case where an Article 4.3 argument was successful. And for reasons of time, I won't go into the facts now. Suffice to say, the balancing exercise was carried out, and an accident that occurred in France, even though it involved UK nationals, it was held that the applicable law was UK law. So moving on to a few more points under Rome 2. If we could just go to the next slide, please, Bernard.
Sorry, Vaughan, I think you said the applicable law in Marshall was held to be UK law, whereas I think the...
Yes, apologies. So, yes, the Article 4.3 argument was successful, and the applicable law, even though it once was considered to be English law, on application of Article 4.3, when considering all the circumstances, the court decided that French law would apply. Thank you, Bert.
No, pleasure.
The other regimes in place in Rome 1 and Rome 2 will continue. So Article 5 contains special rules for product liability cases. That regime will continue. And Article 7 contains special rules for environmental liability cases. And I'm going to talk about the case of Begum further on in the talk that examines the interplay between personal injury and environmental damage. And the last point in respect of Rome 2, the scope of applicable law, once selected, Article 15 governs what issues the law will apply to. So in our example, if the law of Spain is selected, what does that mean? What issues will be governed by the law of Spain? Well, Article 1.3 explains the applicable law doesn't govern evidence or procedure. Those are for the law of the forum. And another case we're going to look at shortly, the case of Pandya, will look at the interplay between Article 1.3 and Greek laws reflecting or concerning limitation. But before I get to those cases, I'm going to hand back to Bernard, who's going to look at the position post-transition period on jurisdiction.
Right, thank you, Vaughan. Yeah, so I'm going to pick up where we are with jurisdiction and enforcement. Okay, well, starting with the present regimes that you no doubt be familiar with, there are any number of subcategories, but essentially there are four main sets, four main sources for jurisdiction rules applied by the English courts in civil and commercial matters. The first, Brussels I recast, is of course the EU set of rules, and that applies chiefly where the defendant is domiciled in an EU member state. So in an awful lot of personal injury cases with a cross-border element, jurisdiction is governed by Brussels I recast. Then the Lugano Convention of 2007, that's the second iteration of the Lugano Convention, the parties to which, as you see there, are the EU, Denmark, Iceland, Norway, and Switzerland. Denmark, of course, being a member state of the EU, but going its own way on civil justice matters. So it's a separate party to the Lugano Convention. Whereas the UK, as we'll see, is only a party to the Lugano Convention by virtue of its membership of the European Union, and that is significant when looking at the future. And then the third set of rules are the common law rules, so the set of rules that English law developed for itself before European law intervened. And then the fourth set that we won't be looking at today, but just to bear in mind, of course, that if the case is a carriage by air case, it is likely to be governed by the Montreal Convention. If it's a carriage by sea case, by the Athens Convention, and more unusually, a carriage by train case, the Berne Convention, or COTIF as it's sometimes known. And those treaties, those conventions, have within them a complete set of jurisdiction rules of their own, as well as rules governing applicable law and enforcement and so on. So they remain unchanged. But that's where we are at the moment. So where do we go after the 31st of December? Well, so post-transition. Okay, well, both Brussels I recast and Lugano will cease to apply, and that magic moment of 11 p.m. on the 31st of December, and the regulation having that effect is set out there. There are transitional provisions which you can see set out there, that the relevant instruments continue to have effect, and the relevant instruments we're concerned with here are Brussels I recast and the Lugano Convention. They continue to have effect in relation to questions of jurisdiction or recognition or enforcement, as if those instruments had not been revoked, if the English court is seized before the 31st of December 2020. When the court is seized is essentially derived from the test that is in Brussels I recast. It's there for the purpose of lis alibi pendens and working out which country's court was first seized. So it's when the document issuing the proceedings is lodged, as long as it is then duly served. So when you issue the claim form, the English court is prima facie seized. If you don't seize it, serve it within 4 or 6 months, then the English court retrospectively stops being seized. But the issue of the claim form is enough for seizing in the first place. So if that happens before the 31st of December, then Brussels I recast and Lugano will continue to apply. I mean, there's an interesting question that I think the answer isn't entirely clear. What happens if you start a case on the 31st of December, relying on Brussels I recast, and you want to join a subsequent European domiciled defendant in 2021, say because the defendant you initially joined blames someone else in their defense, then the question then arises as to whether when you seek to join that new defendant, you do so on the basis of the Brussels I recast rules, or whether you do so on the basis of the common law rules, if it's the common law rules that replace them for these purposes. I mean, one might instinctively think, and I must say I instinctively felt that the question is, you look at the jurisdiction over the particular defendant, the particular party. So if it's a new defendant or a third party that you're joining, then you shouldn't be able to rely upon a now defunct instrument such as Brussels I recast. But if you look at the words there in Regulation 92, that the court is enjoined if the English court is seized of the case in which jurisdiction is founded on Brussels I recast, and it's seized before the 31st of December or by the 31st of December, then it's as if those instruments had not been revoked for the purposes of that case. So it would certainly, in my view, be arguable at least, and I'm not going to predict with confidence the decision either way on it, but it would certainly be arguable that even after the 31st of December, it will be possible to join further defendants or third parties to existing proceedings on the basis of those transitional provisions. It would hopefully not make too much difference in most cases, because the common law has provision for joining additional defendants or joining third parties, which, although they're not worded in the same way that the Brussels I recast or Lugano provisions are worded, will often lead to the same outcome. But that's an issue that it's worth keeping an eye on. Okay. Right. So where do we move once the 31st of December has been and gone, and you've got to start a new set of proceedings? Well, one possibility is the UK becoming a member of the Lugano Convention in its own right. And since every member state is, via its EU membership, a member of the Lugano Convention, as well as Switzerland, Norway, and Iceland, that would mean that the Lugano Convention would apply to govern jurisdiction and enforcement in cases in which the defendant was domiciled in any EU member state or one of those other countries as well. But there are always buts, I'm afraid, with Brexit. The UK made its application to become a party to Lugano on the 8th of April 2020, and you can see the articles if you want to look them up, under which the accession process takes place. So it made the application on the 8th of April. The existing parties to the convention must give unanimous consent to the accession of a new party, which the UK would be, and they've got a year at least to do that. So there's no obligation on anyone to give consent until April 2021. There have been indications of approval from Switzerland, Norway, and Iceland, nothing from the EU, which seems to be playing a slightly harder ball game. Then, if the UK is invited unanimously, it deposits an instrument of accession and then, subject to any further wrangling, becomes a party 3 months after it deposits the instrument of accession. So, in the normal course of events, if the application was smooth, it wouldn't be until about next July at the earliest that the UK would become a party to the Lugano Convention. Now, we don't know for sure, and the terms of the convention have been laid before Parliament in a move that is a little odd, but would be consistent with a hope that there would be some accelerated process for accession as part of a deal. So I would say one would have to watch this space, but as things stand, unless there's a real change, the UK is not going to be a party to the Lugano Convention, at least on the 1st of January. I mean, one would have thought if that was the UK government's intention, it would have been prudent to set the ball in motion at least 15 months before the end of the transition period, but there we are. But it may well be that the UK will become a member of the Lugano Convention, which might pose some knotty problems for people with cases, and they're wondering whether to issue in the first half of 2021 or whether to hold off in the hope of a good outcome of these particular negotiations. Okay, so if we do eventually accede to the Lugano Convention, then what are the rules? Well, as many of you will know, the text of Lugano 2007 follows very, very closely the text of the Brussels I regulation. And by that, I mean Brussels 144 of 2001, not 1215 of 2012. So Lugano is a generation behind in the Brussels rules. And the reason for that is fairly simple. That what happens is that the EU member states get their heads together, decide where they want their jurisdiction and enforcement rules to go, agree those, turn them into a regulation, and then they throw the results at the people who want to be members of the Lugano Convention and say those are your rules, and there's not much more room for negotiation thereafter. So that's what taking back control amounts to, but we perhaps don't need to go there. So if we do accede to the Lugano Convention, it is the case that we will be applying jurisdictional rules which will be fundamentally familiar. There were a number of significant changes between Brussels I and Brussels I recast, but most of the most important rules which cross-border personal injury litigators deal with day in, day out will be similar or the same between the Lugano Convention and Brussels I recast. So domiciles, the governing principle, rules for governing additional defendants or third parties are essentially the same. In particular, the most common basis of jurisdiction in cross-border European cases in English courts, personal injury cases, is the Odenbright jurisdiction, where an injured person sues the insurer of the tortfeasor directly in the injured person's home courts. And that's applicable as much under the Lugano Convention as it is under Brussels I or Brussels I recast. And also there are special rules for consumer and employment contracts which can provide favourable rules of jurisdiction for individuals wanting to bring claims. And there are simplified enforcement procedures. So if we do accede to Lugano, it's not quite back to where we were, but it's a lot closer than the common law. So what if we don't accede? Then you have the common law, the rules which are found in Practice Direction B to CPR Part 6. That covers the general rules of jurisdiction. So jurisdiction based on the domicile of defendant, that's a fundamental rule. it provides for adding defendants or third parties whom one might not otherwise have jurisdiction over if they are necessary and proper parties. So fairly similar to the Brussels and Lugano type tests. You look at the degree of connection between the existing claim against the existing defendant, and you ask yourself whether this other defendant or this third party is a necessary or proper party to allow all the issues to be decided in one set of proceedings to avoid the risk of multiplicity of proceedings in different courts, etc. So those rules, not identical, but they have quite a lot in common. And then there are special rules for contract and tort. The contract rules, somewhat idiosyncratic, different to the Brussels rules. And the tort rules, well, they may or may not be different, and I'll come to that in just a mo. So just want to look at the tort rules very briefly. So these will, in general terms, under the common law, be the most significant set of rules for deciding whether a tort claim can be brought in the English courts or not. The English courts are looking to see whether, and this is if the rules on domicile, etc., don't apply, you can still rely on these rules. So a claim is made in tort and is damage sustained within the jurisdiction, or damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. And I just wanted you to keep in mind for a moment the first part, 9a, damage sustained within the jurisdiction. And the jurisdiction here, of course, means within the jurisdiction of the courts of England and Wales. So I'm going to look at a case a recent decision on that point of damage sustained within the jurisdiction and what the scope of that rule is. And I'm going to do that in just a moment. But I just want first to remind you of one thing, which is a very fundamental difference between the common law rules and the rules of Brussels I or Lugano. And that's that the rules of Brussels I and Lugano are essentially mandatory. They're mandatory upon the courts seized with jurisdiction. So if the rule is engaged, if jurisdiction is established according to the rules of Brussels I recast or Lugano, then in most cases, the court seized has no discretion to refuse jurisdiction. The claimant has a right to bring the claim in that court. There are some exceptions, but relatively few exceptions. Whereas under the common law, there has, since the Spiliada decision in 1987, been an established principle for the benefit of comity of nations, as it's described, that the English court has the power to stay a claim if the courts of another country would provide a clearly more appropriate forum, which might be because the law of that other country applies, although that won't by any means always be decisive. It might be because all the witnesses, all the documents are in that other country, so it's much more convenient to try the case there. You simply weigh all the circumstances and decide. So what that does mean is that even if you can establish the jurisdiction of the English courts at the common law, defendant still has the right to raise an argument that the English court should, as a matter of discretion, decide not to hear the case. Okay. So what happens next? Well, guidance, there's a couple of links here. One to an EU document, which has sets out the EU's understanding of the position. That's from the end of August. And I think on the next page, the end of September, the UK government's position is set out. It's notable that Lugano isn't mentioned. Both parties are keeping their cards close to their chest on what was already extant application of the UK to accede to the Lugano Convention by those dates. Right, thank you. Well, that's the Brexit bit of the talk. Now, Vaughan and I are going to trot through a number of cases. We will try to move fairly quickly. Okay, sorry, I've had a question. I think I won't try to deal with that while I'm speaking, but I hope we'll have time to deal with that at the end. So now the first case we want to look at, before I hand over to Vaughan, apologies for going on for so long, but this follows directly from what I've just been talking about, is the latest instalment in the very, very long-running saga of the Brownlee litigation, which arises from the very sad death of the distinguished international lawyer in Egypt. The case has already been to the Supreme Court and back to first instance, and is unfortunately apparently making its way back up to the Supreme Court again. And the issue with which we're most directly concerned is, what does damage sustained within the jurisdiction mean as the basis for jurisdiction of the English courts? And the reason this is so important to those who have been practicing in cross-border personal injury litigation is this, I think, that by far the most numerous set of cases are those brought in England under the Odenbright principle, where an injured person sues the insurer of the tortfeasor in the injured person's home court in reliance on the rules of the special matters relating to insurance, the privilege given to the weaker party. Now, there are no equivalent rules in the common law. The potential is that all that class of case becomes extremely difficult for claimants to bring in their home courts. But does damage sustained within the jurisdiction potentially allow at least a large proportion of those cases to come back into English jurisdiction? It depends on what kind of damage will suffice. The question is, does it have to be the initial damage, in other words, the injury completing the cause of action, which happens in the foreign country, or will consequential loss suffice? So the typical case, a Brit goes abroad, gets involved in a road traffic accident, suffers an injury, comes back to England, where she or he continues to suffer damage by way of loss of earnings, medical expenses, pain and suffering. And does that consequential damage suffice to ground the jurisdiction of the English court? Well, the Supreme Court considered the matter, and Obiter only, 3-2, thought that it did suffice. But now it's going back to them, and they've said that the issue isn't closed. So at the moment, the most recent decision is 2-1 in the Court of Appeal, going the same way, that consequential loss can suffice. So those cases in which an injured claimant, a Brit abroad, comes back to England, carries on suffering consequential losses here, there is the potential of bringing the case in the English courts. The case is going back to the Supreme Court, unless anyone knows different. Certainly permission for an accelerated appeal was given by the Court of Appeal. But that's the law as it stands at the moment. Remember, though, even in those cases, forum non conveniens can apply. Right, thank you. You've listened to me long enough. I'm now going to hand you back to Vaughan, who's going to talk about the limitation case of Pandya.
Thanks, Bernard. Yes, this is a case with a limitation issue concerning the scope of Article 15H of Rome 2 and Article 1.3 of the same regulation. It was a trial of a preliminary issue. It concerned a road traffic accident in Kos in Greece on the 29th of July 2012. The claimant was a UK national. She was on holiday with her family when she was unfortunately struck by a motorcycle and she suffered a traumatic brain injury. She brought a claim against a Greek registered insurance company pursuant to Rome 2. And you can see the relevant dates on the slide. The claim was received by the court on the 25th of July 2017, just before a period 5 years after the accident. It was issued on the 11th of August, and it was served on the 26th of January 2018. The defendant alleged the claim was statute barred because under Greek law, limitation is only stopped when a claim has been issued and served. And that both of those must take place within 5 years from the date of the accident. Both claimant and defendant adduced expert evidence from Greek lawyers who agreed that service was necessary under Greek law to stop limitation. But the claimant argued differently. On the next slide, we can see Article 15H provides the law applicable to tortious obligations under this regulation shall govern, in particular, the manner in which an obligation may be extinguished and rules of prescription and limitation. So on the face of Article 15H, applicable law included the issue of limitation. But the claimant wanted to read Article 15 with Article 1 sub-rule 3 in mind, which is also on the slide. And that provides this regulation, Rome 2, shall not apply to evidence and procedure. And the claimant argued in UK law and under the CPR, service was a point of procedure. CPR 7.2 provides that the date the court receives the claim form is the date that the claim is brought. And if that was correct, then the claim wasn't statute barred. We can see what Mr. Justice Tipples thought on the next slide. At paragraph 40 of the judgment, he rejected the claimant's argument. He said service of the claim form as a matter of Greek law is an essential step which is necessary to interrupt the limitation period. That's what the experts had told him. Service of the claim form can't be severed, carved out or downgraded to a matter of mere procedure which falls to be dealt with under the English civil procedure rules. That, apart from anything else, would give rise to a different limitation period in England and Wales than in Greece. The clear intention of Rome 2 is to promote predictability of outcomes, and in that context, it seems to me that such an outcome is not what the regulation intended to happen in these circumstances. So the claim was dismissed, but the judgment's useful because it underlines the importance of predictability and consistency. And as Bernard's been talking about, that's something we may lose if the UK fails to join the Lugano Convention, certainly with regards to jurisdiction and enforcement. And although this particular case, it was concerning the specific requirements of Greek law, it does have limitations for us all dealing with cross-border claims and particularly limitation periods, because many countries, not just Greece, treat the filing of the claim form as insufficient to interrupt limitation. Service is often required as well. So with Pandya in mind, it would be well worth checking the particular provisions of the country we want to issue in before deciding that the limitation period will or won't have been expired. The next case is Hutchinson, which I think Bernard's going to talk about.
Yes, well, I will describe Hutchinson very briefly. As some of you will know that many Spanish insurance policies, public liability policies, not motor policies, because it would be unlawful for a motor policy to have such a term, but many public liability policies governed by Spanish law have a term which limit cover to liabilities which have been established before the Spanish courts, which would mean that an Odenbright type claimant might be allowed to bring the case in England, but then the insurer would have a complete defence because the indemnity under the policy wouldn't extend to judgments adjudged by the English court. So in a jurisdiction challenge, the defendant insurer relied upon that term to say, well, the claimant doesn't have a good arguable case because even if he succeeds on liability, he succeeds in showing that there was a tort, he can't succeed in showing that Mapfre, the insurer, is obliged to indemnify under that tort. And the judge said, well, effectively, we don't have to decide the issue finally on a jurisdiction challenge, but to the relevant standard, which is good arguable case, such a term in a Spanish policy may be a kind of disguised jurisdiction agreement. And that would be impermissible under Brussels I recast because it would limit the fora available to the weaker party. and therefore would be an impermissible jurisdiction agreement. It's an odd jurisdiction agreement because, of course, the injured party is not a party to the insurance contract. So in that sense, it simply isn't a jurisdiction agreement at all. But the judge held that, at least to a good arguable case standard, it was. Okay, I think that'll do with Hutchinson. You were going to, I'm conscious that time is getting on. If we want to have a bit of time for questions, we should perhaps try to trot through the next couple of cases briskly. But I'm going to hand over to Vaughan to deal with the Begum case.
Thanks, Bernard. This is a case which contains a novel argument linking personal injury to environmental damage for the purposes of Rome 2. So I'll deal with it as quickly as possible. The claim concerned a fatal accident brought by a widow, and her husband unfortunately died in Chattogram, Bangladesh, when he was working as a shipbreaker under a local employment contract. Now, shipbreaking refers to the practice of, at the end of a ship's working life, it being broken up, and it usually takes place in Southeast Asia. The parts of the ship which has been broken apart can then be recycled or sold or scrapped. And shipbreaking is notoriously dangerous. Unfortunately, a large number of accidents happen whilst it's being carried out. The claimant's husband in this particular case fell from height, and he died whilst he was demolishing a ship, Maran Centaurus. And this ship had been beached at Chattogram 6 months earlier. In particular, this beaching method of demolition is common, but is known to be particularly dangerous. And it involves driving the ship onto the beach and it being dismantled there, where, of course, there's no infrastructure and there's no machinery in place to assist the workers. Rather than sue the employer or the owner of the local shipbreaking yard, the claimant, the wife of the deceased, sued the defendant, Maran UK Limited, a company based over here. And the claimant did so on the basis that the company was involved in the sale of the ship. It was a condition that the sale was for demolition, that it would be sold to a competent shipbreaker's yard. And although the place of demolition wasn't specified, the defendant was taken to have known that it would be in Bangladesh, where it was known ships were beached, and it was known that this could be dangerous. The defendant applied for summary judgment, and it argued that English law couldn't apply under Article 4.3 or any of the provisions under Rome 2. And the choice of law was relevant. If we go to the next slide.
Vaughan, sorry, just before moving to the next slide, I've just seen a typo on this slide. It refers to the company on the second bullet point, the last line, providing ship breaking services. It doesn't, of course. The ship breaking was done in Bangladesh. It provided ship broking services.
Yes.
So,
and it's relevant. Thank you, Bernard, because
right.
the defendant said in this case, well, we're at arm's length from the accident itself. We didn't provide ship breaking services. Yes, we were involved in the sale. Yes, we knew perhaps the ship could end up in Bangladesh, but there's no tort which applies to us. And also, as we can see on the top of this slide, the choice of law was relevant because in Bangladesh law, a limitation period of 1 year applied. So the court needed to consider Article 4.3 and whether the law of England or Bangladesh would apply and how that would affect the limitation period. Article 4.3 is produced again on the slide, and the court found, Mr. Justice J, that Article 4.3 didn't assist the claimant. The accident happened in Bangladesh. All the witnesses lived in Bangladesh. That wouldn't provide the avenue to the claimant to disapply the Bangladesh limitation period. So the claimant instead, as an alternative argument, suggested that Article 7 of Rome 2 could apply. And that's produced on the slide, and it's worth just highlighting the important points. Article 7 applies to tortious obligations arising out of environmental damage. And if environmental damage occurs, the person seeking compensation can choose to base his or her claim on the law of the country in which the event giving rise to damage occurred. Now, environmental damage under Rome II is defined under Article 24 as meaning adverse change in a natural resource such as water, land, or air. Article 25 includes a policy or a suggestion that there should be a high level of protection in respect of environmental claims. The principle being that the polluter should pay for any pollution or any environmental damage that occurs. So the claimant argued that the practice of beaching a ship, as we were discussing, caused environmental damage to the local environment. And if that was so, Article 7 gave her an avenue to choose English law instead of Bangladesh law. The defendant, unsurprisingly, argued to the contrary, arguing that this accident happened when the deceased fell from height. It was nothing to do with environmental damage, and it was nothing to do with adverse change to a natural resource. But the judge, in considering the summary judgment application, held as follows. The defendant's argument that there was no adverse change in a natural resource was an overly narrow reading of Article 7. The proximate cause of the accident was the deceased fall from height, but on a broader approach, the accident resulted from a chain of events which led to the vessel being grounded at Chattogram, in consequence of which damage was no doubt caused, at the very least, to the beach and tidal waters. Assuming that the claimant has a sustainable argument that the defendant committed a tort, it's far from obvious that the present case isn't caught by the spirit of Article 7. So the application for summary judgment was dismissed. The case is important because of the novel reading of Article 7, although perhaps it was a surprising interpretation because the stretching of the concept of environmental damage to this personal injury claim was rather novel. And you'll see at the bottom of the slide, the case is going to appeal. It's going to be heard early next year, and it will be interesting to see what the Higher Court has to say about this interpretation. I'm conscious of the time, Bernard. The next case I was going to deal with was Roberts, which is a case dealing with Civil Liability Contribution Act, but perhaps for reasons of time, you deal with Troke, and we can take some questions instead.
Yeah, well, I agree, Vaughan. I think so. I think there are three more cases on the slides, but you'll all get a copy of the slides. There's Troke and Amgen, which is a case helpful to those trying to avoid the particularly the penalty interest under Spanish law, which I'm sure many will be familiar with, that after 2 years it goes to 20% per annum. So if the case takes a while to come on, the interest can be as high as the quantum, because the interest is not just on past losses, but it's on all losses. So a helpful case there for defendants, where it was held that that was a procedural provision in Spanish law, so not automatically applicable. Don't know whether that's going to go on appeal or not. There's Roberts, the case that Vaughan was going to speak about, which says that the Civil Liability Contribution Act 1978 applies to, has extraterritorial effect, in short. And finally, there's the Aspen case, which is a significant case more in the commercial field on the scope of the matters relating to insurance in Brussels 1 recast. But they're there for you to read if you'd like to. And because we're conscious that the hour is almost up, and it would be useful if anyone has any questions that we can deal with them at least very briefly. Vaughan, any questions that you want to deal with in the short time we have left to us?
Yes, thank you, Bernard. We did have a question before the session, which I thought I'd deal with. And the question is as follows. Do you think it's premature to issue a claim form before the 31st of December 2020 for a Spanish accident in August? There are UK handling agents for the Spanish insurer, and we're still in the protocol period, but want to deal with over here so we can recover costs, is the email that's been sent. And I'd suggest, certainly considering what we've been talking about today and the uncertainty that will arise when the transition period ends. It would be preferable, if you feel you're in a position to assess liability at this stage, to issue now, because we do have some clarity with respect of the law currently in place, and that will vanish, certainly in respect of jurisdiction and enforcement, if Lugano isn't entered into, and if no further agreement can be entered into. There's obviously an issue in respect of issuing whilst you're still in the protocol period, and it may be, unfortunately at the moment, that you're not in a position to assess the merits of the case. But it would be worth, I would suggest, taking a possible argument that you've issued prematurely to have the benefit of the regime currently in place, as opposed to issuing on the 1st of January 2021, when the position will be much less clear. I don't know, Bernard, whether you agree with that.
No, I do. Obviously, it's easy for us to talk. We can say, yes, issue away, but of course, solicitors with a heavy caseload know how expensive the issue fees are. And if you don't know where you are with a case, it may be a hard decision to take. But if it's at all practical, I think it must be prudent to try to seize the jurisdiction of the English court while you have the certainty of Odenbright, etc. Yeah. Okay. There's a question to confirm that we did, or I did, mean what I said, that in order to seize the jurisdiction of the English court pre-transition, you just need to issue proceedings and not serve pre-transition. That is correct on my understanding of the rules, but of course, if you don't subsequently serve properly, then the English court will never have been seized, as it were, or you will retrospectively lose the seizing of the English court. And do bear in mind that the service regulation, which provides for easy service within the EU at the moment, is one of the instruments which lapses on the 31st of December. That's not usually so dramatic because all, or at least, if not all, almost all member states of the European Union are parties to the Hague Convention on Service of Judicial and Extrajudicial Documents. I think it's called, I think of 1965. So that provides for relatively easy service, but do be careful. So in other words, don't waste time, don't leave it to the last minute to try to serve if you issue shortly before the 31st of December. Okay, I've got a question which I'm not going to answer. I don't know whether Vaughan is going to put his neck on the block, but I don't know the answer to it. On a court being seized, what is the position of a claim form being sent to the court before the 31st of December, but not issued until January 2021? I mean, there are special, obviously we all know that there are special rules for the running of time for limitation purposes, but it's not a universal rule that sending the claim form to the court is enough.
Yes, I mean, it touches on the issues in Pandya that I was discussing, although you're right, it is not necessarily a limitation period. But I'd suggest that it depends which country is being seized, because in the UK, we know under the CPR that a claim form being sent to the court and not being issued is relevant for the purposes of limitation, certainly. So I think it would depend on the particular law of the country in question. It's obviously much easier to decide the position in the UK courts than, say, Greece, France, Spain, where we'd need some expert evidence on that issue.
But I mean, the general message is, as always, you know, try not to be running to the court office between Christmas and the New Year to issue proceedings, because things can go wrong, as we know. Okay, where there is a UK handling agent for a foreign insurer in relation to a domestic incident post 31 December, will a right of service exist to serve on the UK handling agent? And as many of you will know, at the moment, there's mandatory handling agents or claims representatives, as they're strictly known. which were first introduced by the Fourth Motor Insurance Directive, and every motor insurer operating in the European Union has to have a claims rep in each member state. And the ECJ has held that, so in an English case, for example, you can serve on the foreign insurer that you're suing at its claims rep office. So that means you can serve in the UK, you don't have to serve abroad. Does that still exist? Well, I think it's very unlikely. I can't say that I've specifically investigated it, but the motor insurance directives and Brussels I recast disappearing. I mean, obviously the motor insurance directives have resulted in a lot of domestic legislation which will not necessarily disappear, but the European scheme will be disappearing. I do not think that it would be at all prudent to assume that you can continue to serve on the claims rep in the UK. That's not definitive. That's really very much a preliminary response. Vaughan, I don't know whether you have any thoughts on that one, or whether we...
No, I think the advice given, especially with the the reservation that it's very much a preliminary view, I'd certainly agree with.
Yeah. Well, thank you very much to all of you for your attention. We can't see you, but we appreciate your attendance this afternoon. And as I say, you'll receive a copy of this, and it will also be available on the website. So if any of your colleagues missed it, would be interested in seeing it, then they can access it there when it's posted. So thank you very much. Good afternoon.
Thank you, Bjorn.